Another question. You were here in July, and you said that you commended Dodd-Frank for providing a blueprint to get rid of too big to fail. We've now understood this problem for nearly 5 years. So when are we going to get rid of too big to fail?
Well, some of the, as we've been discussing, some of these rules take time to develop. The Orderly Liquidation Authority, I think we made a lot of progress on that. We've got the living wills. I think we're moving in the right direction. If additional steps are needed, then Congress obviously can discuss those, but we do have a plan, and I think it's moving in the right direction.
Any idea about when we're going to arrive in the right direction?
It's going to take, it's not a 0-1 kind of thing. It's over time.
The concern that you have raised is one that I frankly share. And I'm not talking about HSBC now, because that maybe that not be appropriate. But I am concerned that the size of some of these institutions becomes so large that it does become difficult for us to prosecute them when we are hit with indications that if you do prosecute, if you do bring a criminal charge, it will have a negative impact on the national economy, perhaps even the world economy. And I think that is a function of the fact that some of these institutions have become too large.
Tell me a little bit about the last few times you've taken the biggest financial institutions on Wall Street all the way to a trial. Anybody? I appreciate that you say you don't have to bring them to trial. My question is, when did you bring them to trial?
We have not had to do it as a practical matter to achieve our supervisory goals.
Can you identify when you last took the Wall Street banks to trial?
I will have to get back to you with the specific information.
"2009, Back from the Brink." It sounds like a movie title. It really describes the financial markets. Mortgage securities, municipal debt, they've surged in recent months as it appears the U.S. economy has avoided depression. There is still one major market that continues to be locked up, however. I'm talking about auction rate securities. 18 months after investment banks quit supporting the securities, more than 400 companies are stuck with $22 billion worth of the debt. And according to the New York brokerage firm Second Market, the securities are selling at losses of as much as 40 cents on the dollar.
The Sarbanes-Oxley Act was introduced into Congress by U.S. Senator Paul Sarbanes of Maryland and U.S. Representative Michael Oxley of Ohio. Their intention was to create a law which would restore the faith of investors back into corporate America. By imposing stricter standards on financial reporting, there would be an increase in the reliability of the financial statements created by any given company. Let's take a deeper look at what the Sarbanes-Oxley Act includes. First, officers of the company are required to sign financial statements for accuracy. This holds them personally accountable for any misrepresented data. Second, an increased fine and/or prison sentence was set for individuals who attempt to defraud investors or misrepresent actual figures.
Today, the Insider Exclusive goes behind the headlines in Wall Street's $336 billion fraud in auction rate securities. To examine how Brad Gildy, founder of the Gildy Law Firm, is successfully pursuing justice on behalf of victimized individual investors and organizations, such as student loan lenders, port authorities, universities, healthcare providers and groups, housing and financing agencies, governmental and quasi-governmental entities, many of whom were misled by Wall Street's institutions including Morgan Stanley, Citigroup, Merrill Lynch, and UBS AG, who marketed these securities as being a safe investment, although it was later found otherwise and investors were misled. Many were told that the market for ARS was completely safe, completely liquid, just another form of AAA-rated cash equivalents. What they failed to disclose to their clients was that the financial market was in serious trouble. And only when the investors were told that the then $336 billion market was frozen in early 2008 did investors learn that it was a scam. Underlying bonds and preferred stocks were not liquid at all, but were distressingly long-term. This massive fraud perpetrated on America by the Wall Street gang in this insider-exclusive investigative TV special is explained in easy-to-understand detail by Brad Gildy, who is successfully representing many of these victims. Brad provides real insight into the criminal subculture of Wall Street and the shady dealings of Wall Street brokers and their handling of their clients who bought auction-rate securities and then hung them out to dry when the market for them collapsed, and what victims can do about it now. ARS interest rates were higher than money markets and were sold as completely safe, liquid, AAA-rated cash equivalents, a deceptive sales pitch that lured hundreds of thousands of investors to buy the securities. While this is a classic 21st century tale of Wall Street greed and betrayal, it is also a story of redemption and the life-altering struggle of American investors and others around the world who, in the end, are successfully fighting the Wall Street fraud masters. Remember, America is a nation of laws and allegedly follows the rule of law, implying that every citizen is subject to the law, in contrast to the idea that the powerful and wealthy are above the law by divine right. However, the law is hardly applied without distinction in this country, evidenced by the very small number of wealthy bankers and powerful financial leaders imprisoned for crashing the world's economy during the financial meltdown of 2008. Over the past couple of months, large financial institutions have begun being held accountable for cheating investors and earning billions of dollars in the process. But aside from paying fines and plea bargains and possibly compensating bilked investors, it is still impossible to jail a bank or a corporation. But the people responsible for raping investors and stealing companies can be prosecuted and jailed, but sometimes it appears they are too rich, too powerful, and too big to jail. In fact, Lloyd Blankfein, Goldman Sachs CEO, told a news interviewer that he believes banks have a divine right to special treatment because they are doing God's work. According to him, we're very important. We help companies to grow by helping them to raise capital. Companies that grow create wealth, and in turn, this allows people to create more growth and more wealth. It's a virtuous cycle. Financial institutions may not face prosecution because they cannot go to jail, but the men and women committing fraud, money laundering, and deceiving investors can be criminally prosecuted and sent to jail. However, financial institutions can be forced to make restitution for billions and billions of dollars they stole from investors and struggling firms. The rule of law cannot be arbitrary based on whether or not a financial giant is prosecuted and fails, or if men like Goldman Sachs CEO claim they are doing God's work and serving a social purpose. 5+ years after the meltdown of the largest fraud ever perpetrated on Wall Street, the nightmare that defines the world of auction-rate securities goes on. While Wall Street, Washington, and the media would very much like to leave the pain encompassing the ARS market largely in the rearview mirror, for many individuals who still hold on to the hope that they may ultimately get repaid in full from these widely distributed cash surrogate instruments, the pain and anxiety remain front and center. Brad Gildy is one of the top auction rate securities lawyers in the nation, who is successfully holding fraudulent brokers accountable and helping victims to recover their money. And if you're one of the thousands of investors nationwide misled by an investment firm advising you on auction rate securities, don't remain in financial limbo with your funds frozen in what you once were told was a safe cash investment. Brad Gildy has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Houston, in Texas, and across America. His goals, not only to get justice for his clients, but to make sure banks and investment houses are held accountable. These successes drive him to help more people who have been harmed by Wall Street firms. Brad has built a substantial reputation by consistently winning cases other law firms have turned down. His amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Houston, Texas. It is my great pleasure and privilege to introduce Brad Gildy to the show. Welcome to the show, Brad.
Thank you.
Tell our audience a little bit about what type of law your law firm practices.
Gildy Law Firm specializes in personal injury trial cases. We also do complex commercial litigation cases. We represent individuals and sometimes businesses on complex commercial cases. And in this case, we represent governmental units and quasi-governmental units in auction rate securities litigation.
And for a lot of our audience, they've never even heard of auction rate securities, and yet it is probably the biggest massive fraud ever perpetrated on the American public by the Wall Street firms. $336 billion, I think, the total fraud. Tell our audience what an auction rate security is. It almost sounds like a credit default swap, which people still today don't know anything about.
Sure.
Auction rate security. What is it? What's it do? What's its purpose?
Its purpose was to provide funding to, quasi-governmental units, to entities like the Port of New York, Port of New Jersey, for example. It would provide long-term debt with short-term variable rates, and these rates would reset at what's called Dutch auctions every 7, 14, 28, or 35 days. Mm-hmm. And the way that it was marketed to these governmental units or quasi-governmental units like municipalities was that they could get money now, and in return for which they would pay a variable rate that was probably lower than the long-term rate.
So it's cheap money,
cheap
supposedly.
Money. That's how they were sold, and they were sold to issuers like ports, hospital groups, student loan foundations. Mm-hmm. They were pushed by brokerage firms.
And these pushed by underwrote.
Yes, underwriters would push these and sell these to the issuers and induce them to participate in this market. But the problem was the market was created by the underwriters.
And these are the Wall Street firms.
Correct.
The big ones.
The big ones.
Yeah.
We're talking about, Bank of America. We're talking about Merrill Lynch, UBS, Citigroup. These were the large banks that induced these municipalities to participate in the market that they actually created, and then they withdrew. And when that happened, all of us suffered.
Now, when you say they withdrew, what exactly happened? They created a product, and it was to the benefit of these organizations that you talked about, and when they withdrew, they closed down the market, 2008, right?
They did. The market ended in about mid-February 2008.
And part of them selling this product was they basically said, we will always be there. This is a market that you can trust and use. And then all of a sudden they did a 180. Sure. Why?
It was kind of part of the perfect storm. In February of 2008, we had just seen the financial collapse of the subprime mortgage fiasco that happened in 2007. Mm-hmm. And so there were a lot of issues, a lot of financial issues at that time that kind of created the perfect storm that caused the failure of the auction rate securities. But simply, the underwriters who had created the market just withdrew. They did not want to participate in this market anymore. And because they were the only bidders, once they withdrew, then the issuers who had backed all of these instruments were stuck with the higher rates.
Yeah, now let's talk about an example, Port Authority of New York.
Sure.
Let's say they bought auction rate securities. Now the market has dried up. The people who make the market, the Wall Street firms, what would the Port Authority of New York have to do then, and what were the damages to them as a result of them doing some alternative thing to get money?
Sure. Just by way of example, let's say you're the Port of New York, Port of New Jersey,
yes,
and you want to repaint the Brooklyn Bridge. Mm-hmm. And you need to hire people to go out and strip the paint and paint. You need additional security, things of that nature. Mm-hmm. That's an enormous expenditure and an enormous cost. And perhaps the tolls or the taxes that you're collecting you don't have the revenues to fund that project. And so an underwriter would approach the Port of New York and say, well, let's participate in an auction rate security. You can issue a municipal bond, you can sell it, we'll give you the money up front, and you'll be stuck with a variable rate that will change at auctions, but your rate will be lower than a long-term rate. So this is good money now for a long-term debt with a variable rate that's very favorable to you. What happens is when the underwriters pulled out of this market, you were
saying that they're no longer going to have this Dutch auction.
Exactly. Yeah. When the underwriters pulled out of this market, by virtue of this auction rate security, it fell to what's called the default rate or a penalty rate. And the penalty rate, of course, was much, much higher than the variable rates that they had seen in the auctions. And so, for example, if you issued a $1,000 auction rate security and you were expecting a variable rate to fluctuate between 3 and 5%, when you were now faced with that penalty rate, that rate could go as high as 20%.
Now, the penalty rate kicked in because they could not auction it off at a similar rate as they had before, correct?
Correct.
There was no place to get it, correct?
Bidders were not purchasing these auction rate securities.
Okay, now the penalty rate was built into the language of the auction rate security, right?
Correct.
And who would be charging him this, let's say 10% percentage points more? Who would be charging him?
The underwriters.
The same people that withdrew from the market.
Correct.
So they're saying we're no longer going to conduct the market because you have no place to sell it or renegotiate it. We're going to charge you a lot more money because that's what you agreed to before, right?
Correct.
All right.
And so now, you know, these...
This is like changing the rules as we go along, right?
Sure. And that's precisely what happened. And so, you know, the Port of New York, Port of New Jersey, for example, they're now paying 20% when they otherwise would have paid 4%. Their damage model is the difference between 4 and the 20%.
And the beneficiary of that increased interest rate are the same people that withdrew from the market, the same Wall Street firms, right?
Sure.
Now, you have $336 billion in 2008 that is no longer liquid, basically. You know, there's no place to renegotiate a similar type interest rate.
Right.
What happens next?
Well, the SEC, the Securities Exchange Commission, did get involved.
Yeah.
And when they did, they were able to negotiate and help customers who had purchased the auction rate securities and getting some of their money back.
And how would they do that? Would they send a letter to Morgan Stanley, for example?
Sure. There were investigations. There were complaints filed. There were settlements from these groups. And by virtue of those settlements, some of the customers were able to get back some of their money. They were able to get back the par, you know, the par value or the face value of the auction rates and get back some of the interest that they had spent. But for those that were left out, they're now either left holding the bag or their other option is a civil suit.
Yeah. At this stage of the game, this is 2013, I have read that out of the $336 billion that originally was at risk, something like $100 billion has been settled, correct?
Correct.
Is that $100 billion of the original 336, or is that $100 billion that has been paid out and settled, which could represent 50% of the market?
Sure. It's less than 50%.
Yeah.
Auction rate securities began in around 1984.
Yeah.
And from 1984 till about February of 2008, that market had grown to about $360 billion. Almost half of that, in fact, more than half of that, was auction rates with respect to municipalities like the Port of New York, Port of New Jersey, Port of Houston, that were stuck with a significant amount of these auction rates. $100 billion has been settled, most of that successfully through the SEC, and that has been paid back to these entities.
There are quite a few lawsuits that are pending against some of these issuers, correct?
Yes.
Not against the issuers, against the Wall Street firms, right?
Correct.
What has, and you're one of the firms in America that's right on the leading edge of having these things, of doing these things. what are the issues that you have to prove in this case? Because, and before you answer that question, let's talk about when they were originally marketed. They were marketed by the Wall Street firms as the cash equivalent, correct?
Correct.
At any time you could cash this in, correct? Talk about some of the deceptions that Wall Street perpetrated on America and these firms.
Sure. These large banks basically induced customers, induced issuers to participate in a market that they created.
Yeah.
And the way that they did so was to suggest to the issuers that this market was deep in blue, that it was like the ocean, that there were so many bidders that you never had to worry about the auctions failing. Because if the auction fails, if there's not enough bidders, you don't get the clearing rate. It goes to the default rate, and the default rate, of course, is much, much higher. Yeah. And that had largely been the case from 1984 until about February of 2008. We began to see some failures in 2007, but overnight, literally in February 2008, the underwriters pulled out and left everyone else holding the bag.
Mm-hmm. Now, what was their defense? What did they say to the SEC, for example? What did they say to, the people that they put at risk as their defense?
Sure. The defenses are that a lot of this information was disclosed, that it's found within the financial documents regarding the auction rates, that this information was disclosed. So, the issues that were faced on a civil side is a little bit different than the issues faced from the SEC on their side. In order to bring a cause of action civilly, you can bring claims under Section 10B of the Securities Exchange Act of 1933, but you have to show a number of elements, one of which is reliance. You have to show that they were deceived and that they relied on that deception. So kind of basic elements of fraud. Yeah. And courts have ruled against plaintiffs, ruled against the municipalities because of their inability to show reliance or that they were somehow defrauded.
Why? Why have they ruled against them? I mean, it seems to me that, let's say all that information is in the fine print.
Sure.
There was somebody selling it to. Has anybody got a hold of the pitch of how they were supposed to be marketed to show that with the combination of, even if it's in the document, it was presented in a different light? That's fraud, isn't it?
It certainly is. I think the reason why there's been mixed success is because you are dealing with fairly sophisticated entities. Yeah. And so you've got entities that participate in financial instruments, participate in the market. Yeah. And so really to prove reliance, to prove that you did not know what was going on is difficult.
Mm-hmm. So how is your firm and other firms successfully encouraging these firms to settle these cases?
What we do is most of our cases are filed in a FINRA court. FINRA courts have a kind of a reduced burden of proof, so to speak.
Right. This is the old NASD arbitration.
It is much like arbitration.
Yeah.
It's a 3-judge panel. Yeah. There is no dispositive motion practice. Yeah. There's limited expert challenges. These cases are very complicated because they're document driven, they're very document intensive, right, and they require experts. But we have been successful in litigating these cases in a FINRA court between judges representing our clients and showing that they were in fact frauded, that there was in fact fraud.
One of the final words, what is the current status of many of the cases that you're working on right now in trying to recover money for these auction rate securities for your clients?
Our cases are doing fine. We've got several that we are joint venturing with other law firms. Yeah. Because it is so document intensive and expert rich, it's oftentimes more favorable to pursue with pooled efforts. And so the firms that I work with, we have a number of cases that are filed that we've settled, and that we're successfully litigating
Yeah.
in the FINRA courts. And I would encourage those that may have been victimized by this practice to seek legal help.
Yeah, and you seem to be the right legal help because this is complex and there's a lot of money at stake. And we certainly appreciate you taking your time today to explain a little bit about auction rate securities and how America was fleeced, and hopefully it won't happen again. Thank you. Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.